Good afternoon, everybody. We hope that you're doing well. I'm David Dupperly, and William Floyd and I are going to be your presenters today. And we're going to be talking about some timely discrimination issues. I'm going to be going through the 4 ADA questions that were included on the announcement for the webinar, and that these are questions that are particular to the COVID-19 situation. And then William is going to be talking about some other recent developments in the areas of sex discrimination and religious discrimination. And to answer 2 questions that you might have, number one, Mickey is going to be sending everybody the PowerPoint slides after the webinar. And number 2, there is a chat box for you to ask questions during the presentation. And we will do our best to get to those questions. If we don't get to some of them, feel free to follow up with us later. But we will try to get you out of here in 1 hour. So let's dive into the ADA part of the presentation. And just by way of overview, and I do have some additional kind of ADA basics slides, but as you know, the ADA generally prohibits medical inquiries and exams, at least to the extent that they might exclude employees and applicants who are qualified individuals with a disability from the workforce. So that's one of the 2 main principles of the ADA. And the other one is the requirement to provide a reasonable accommodation if requested by an employee or applicant. And we're going to apply those 2 principles then to the 4 questions that you see on the bottom of this slide. And to go into just a little more detail on the ADA before we dive into the questions, as I said, and as you know, it prohibits discrimination against a qualified individual with a disability, and that is somebody who could do the essential functions of a job despite any disability they may have, with or without a reasonable accommodation. And disability, especially after the ADA Amendments Act a few years ago, is defined broadly, and it includes a lot of conditions. It doesn't necessarily include COVID-19, but it includes a lot of other conditions. And so the prohibition against discrimination includes conducting medical exams or making medical inquiries, and of course, a temperature check, a COVID test, those things are all medical exams. But even though there is that prohibition, there are a couple of exceptions. And the exception that comes into play most often is it is okay to do a medical exam or make medical inquiries if they are job-related and consistent with business necessity. And then there's also another exception or defense that an employer, if an employer has a reasonable belief that an employee poses a direct threat, then a medical exam or inquiry may be okay. Also, the ADA has some very strict confidentiality requirements. They are waived or modified a little bit in some specific ways that the EEOC has provided for, and we will talk about those in a few minutes. The prohibition against discrimination also involves making reasonable accommodations for a qualified individual with a disability if an accommodation is requested. And an accommodation is just kind of a big word that means a change or a modification in the work environment that would enable an employee to do the job. And there are kind of some general points to keep in mind here. If an employee requests an accommodation, then the employer and the employee or the applicant have to engage in the interactive process, which is another big word that basically means, or term, that means having an interactive discussion. And both the employer and the individual have to show some flexibility. But the interactive process is where you go back and forth and you ask about the request and what the basis for it is and try to talk it through. Now, as you can see from the next two bullets, you're not necessarily required to grant an employee's requested accommodation if it would impose an undue hardship on the company. And an undue hardship is another one of these kind of like terms that are in the ADA. An undue hardship is something that would be a significant difficulty or expense for the company. And another thing about reasonable accommodation is it is okay to exclude an employee from the workforce whose disability poses a direct threat that can't be eliminated or reduced with a reasonable accommodation. When you go through this interactive process, of course, you want to kind of document the company's good faith efforts to engage with the employee to try to find a solution to their request. So the last time that there was a pandemic was 2009. There were actually several pandemics in the early 2000s. The last one was in 2009. It was the H1N1 pandemic, which most people refer to as the swine flu pandemic. And when that pandemic hit, the EEOC issued some guidance that said, listen, the ADA continues to apply, but what the CDC is recommending that you do to keep your workplace safe, you can still do those things that the CDC is recommending, even though in normal circumstances they might be problematic under the ADA. And back in March, at the beginning of the COVID pandemic, the EEOC reiterated that guidance, and then they've updated that guidance a few times, most recently on September the 8th. And if you go to the EEOC website, they basically have two guidance documents on COVID-19. The one we're going to refer to here for the next few minutes is the one that you see on this slide. It says what you should know about COVID-19 and the ADA and so forth. And this position that the EEOC has taken kind of captures the tension that employers face, which is, number one, you want to keep your employees safe. Not only is that your natural desire and what you want to do, but it's required by the Occupational Safety and Health Act, which is enforced by OSHA. That act has a general duty clause that basically says you have to provide a workforce for your employees that is free from any known dangers. So you got to do that, but then the ADA says you can't discriminate based on somebody's disability. And there is a balance that has to be struck there, and the EEOC itself has said you can strike that balance by definitely following the CDC recommendations and the EEOC and the OSHA requirements. So to talk about the first of our four questions, can we require employees to pass a COVID-19 test before they come into work? The answer to that question is yes. And if you go to that EEOC document that I referred to a minute ago, the one that was updated on September the 8th, it has like 5 sections. And the first section, which is Section A, is all about medical exams and inquiries. And this one specific question, A6, makes it clear that, yes, it's okay to require employees to pass a COVID test because that requirement meets the ADA standard of being job-related and consistent with business necessity. And also an employee with COVID would pose a direct threat to others in the workforce. So that's a fairly easy question to answer. Now, the EEOC has written like 3 or 4 pages of guidance on this question, and so to kind of break down a few more issues, it's also okay for the employer to even administer a COVID test at work and kind of to do it on their own, in connection with a nurse or a doctor's office. But the main thing to keep in mind here is that the second one up from the bottom, the antibodies test, that doesn't test for active infection, so it's not considered to be job-related and consistent with business necessity. So that one is out. And the same idea applies to temperature checks and answering the COVID questionnaires. As long as you're asking questions that the CDC says are okay to ask and you don't go beyond those questions. And we've been working with these questionnaires for several months now, so I don't think that's controversial. The confidentiality requirement, as I said a minute ago, it's somewhat waived or modified in this context. It's okay to report the name of an employee who tests positive to DHEC in South Carolina and other public agencies in other jurisdictions. It's okay for a temp agency to tell the worksite employer if somebody has COVID-19. It's okay for a coworker to tell a supervisor that they understand that somebody else in the workplace has COVID-19, and for that information to go up the chain, as long as the employer is making every effort to limit the number of people who find out the employee's name. It's also okay to, for the employer to do what they got to do to implement contract tracing without revealing the name of an employee who's got COVID. And if an employee is working from home because they tested positive, you can't tell other employees why that employee is working from home. So this is all discussed in the EEOC guidance. Another thing the EEOC tells us is that COVID testing is not for employees who are working exclusively from home, because they don't pose a risk to coworkers or customers or anybody else. And you can see some other principles on this slide. You can't single a particular employee out unless you've got a reasonable belief that they may have the disease. And you can't ask about family members, because that would be a violation of GINA, the Genetic Information Non-Discrimination Act that was passed several years ago, because it prohibits asking about family medical history, but it is okay to ask if an employee has had contact with somebody who has the COVID symptoms. So now let's transition to our second question about the COVID vaccine, which of course has been a big deal in the news the last few days. And as you know, there's basically, if you exclude the vaccines coming out of China and Russia, there's basically 6 other ones. And the first one, the one that's supposed to be approved tomorrow for use during the pandemic, is made by by 2 companies, Pfizer and BioNTech, And then there's another one that's, I think, supposed to be approved next week. Next Thursday, and that's the one made by a company called Moderna. And then there's a couple of more that are going to be up for approval a couple of weeks after those first two, and then there's a couple more, one made by Sanofi and the other by Novo, somebody or other. So there's going to be 6 vaccines available to people in the United States, and the first 2 are like more successful beyond what anybody hoped they would be as recently as a couple months ago. They're like 95% effective. Yesterday it was announced that the first one that's being kind of put under the microscope, so to speak, the Pfizer one, does have side effects for more people compared to just the flu vaccine. But these vaccines are hopefully going to let us all get back to normal within about 6 months. The first vaccine, the Pfizer vaccine, is supposed to start being available to healthcare facilities, long-term care facilities. Well, those 2, starting within a few days after tomorrow. And the idea is that there's the long-term care industry involves about 3 million residents and workers, and I think they're pretty much in line to get it first. And as we've all read, I think CVS and Walgreens, they have a contract with the government, specifically with an agency called CMS, to come into the long-term care facilities and set up clinics and vaccinate people there. So that's all going to get rolling really soon. So to answer the question, can or should we require employees to take a COVID-19 vaccine? That is a question that most employers, for now, will say no. We're not going to mandate it. We're not going to require it because there is a lot of skepticism out there. I think the skepticism, for the most part, is going to go away once the celebrities and the former presidents and all those kind of people start getting it on national TV. I read somewhere that back in 1950, a lot of people didn't want to take the polio vaccine, but when Elvis Presley took it on national TV, then all of a sudden it became the cool thing to do, and everybody wanted it. So we do have some experience to draw on on the flu vaccine. It's pretty much a requirement at hospitals, doctors' offices, nursing homes, child care facilities, and what the EEOC said in 2009 when a vaccine came out for the H1N1 flu, they said that the vaccine is a medical exam, which implies that it's okay to require it if it's job-related and consistent with business necessity. But the EEOC said you've got to consider any request for an exemption or for a reasonable accommodation based on a medical reason or a religious reason. However, the CDC has several web pages on like just the flu vaccine and how safe it is, and how because some people object to the flu vaccine, and they have really good responses to most of the objections that people have to the flu vaccine. So there are going, as far as religious exemptions go, just having a problem with the idea of vaccination is not a religious belief. So requests for exemptions based on medical reasons or religious reasons, there's going to be a number of them that are valid, but there's going to be some that are not really valid. And for those, you just, you ask it's like going through the interactive process with anything else. You ask the employees for documentation, certification from a doctor when it comes to a medical issue, and maybe you consult with the company's doctor and make a decision on that. I've got a screenshot here of a couple of the CDC web pages that address safety issues and connected with the flu vaccine. And we can expect to see the same thing with the CDC addressing safety issues with the COVID vaccine over the next few weeks as people get it. And of course, when the FDA evaluated, the only one they've really published a study on was yesterday on the Pfizer vaccine, and they did make a note of the side effects that a number of people experience from that vaccine. But those are all going to be addressed, and over the next few weeks, I think a lot of questions about the vaccine are going to get answered. As I said, we have something to go by, especially with healthcare, long-term care, and child care employers, because they've been requiring the flu vaccine for a long time. And there's nothing necessarily stopping other kinds of employers from requiring the vaccine, but that may be something that employers look into doing a little bit down the road once people get a little more comfortable with the idea of the COVID vaccine. There may be some state and local governments that prohibit employers from requiring it, and there might be others that, you see all the disagreement just over mask wearing. There might be other jurisdictions where they say, an employer can't require it. So we'll have to wait and see what comes out from state and local governments. If your facility is unionized, that might be something that a mandatory subject of bargaining. Some more considerations in thinking about this question. It is possible that the EEOC or OSHA could say that specific kinds of employees do have to get the vaccine. People who work in close proximity with patients or with other employees, as opposed to people who work in large warehouses where they can easily distance from others, or people who work at home, or people who work in offices where there is already a lot of separation built in. The main thing to think about in coming up with a COVID vaccine, especially if you're outside the healthcare and long-term industry, is what if employees refuse? And then what are you going to do? And, you can be guaranteed that employees are going to refuse. Again, we look at our experience with face masks. And if employees refuse and the employer doesn't address the employee concerns correctly, the employer could run up against some protections in the National Labor Relations Act and in it says OSHA, but it should say the OSH Act and the anti-whistleblower provision. And this is specifically what OSHA said in 2009 during the H1N1 pandemic. They said employers generally may require employees to take vaccines, but that if an employee refuses based on concerns with the side effects, how they will affect them personally, the employee may be protected by Section 11C of that statute. So those are two things to keep in mind before diving into policy on mandating the vaccine for everybody. There was a Gallup poll that came out a few weeks ago that said that 42% of people are saying they will not take the vaccine. And this is important information for employers to have in deciding whether or not they want to mandate this. And I think it kind of cuts against doing a mandate if you don't have to initially. The nice thing about the number about this graph is it shows that the people who are willing to take the vaccine is going up, and the people who don't want to take it the people who don't want to take it, that number is getting better all the time. And some new numbers were released on that question by another poll yesterday. So it is anticipated by people who make predictions in this area that there's going to be much wider acceptance of the COVID vaccine within a few months. The people who are not interested in taking the vaccine yet, this slide is just a partial slide because I couldn't fit it all on one slide, but according to Gallup, this is of the people who don't want to take the vaccine yet. These are the concerns that they have. Concerns that the vaccine was rushed because, kudos to the government and all these pharmaceutical companies that they came up with a vaccine that is 95% effective in a matter of months. That's quite an accomplishment. I think it's something that a lot of books are going to be written about and that we'll be talking about for a long time. So this slide just says if you are adopting a mandatory policy, plan for how you're going to handle people who want an accommodation or an exemption. Those of you, again, in healthcare and long-term care, you already have likely forms that you get employees to sign when they want an exemption from the flu vaccine, and you can just use those same forms for the COVID vaccine. And a lot of times it's good to have the employee explain, okay, this is why. Why do you not want to take the flu vaccine? And show us, get your physician or your healthcare provider to sign that the vaccine is not appropriate for you, and then you go into the interactive process. And employers who mandate the vaccine, the COVID vaccine, will be doing pretty much exactly the same thing now. There are some differences in the two vaccines, but as far as this process is concerned, it's going to be about the same. If employees have a valid medical or religious reason for not taking the vaccine, here are some the main accommodation you would provide is more PPE. That kind of, again, it predates COVID with the flu vaccine issues. But as you see toward the bottom of this slide, the alternative strategy is to have a voluntary policy at this point and to encourage employees to get it. My understanding is once the COVID vaccine becomes available to the general public, which will be sometime between February and April, it's gonna be given at CVS's and at Walgreens, and people will. They've developed an app for this, and the two drug store companies say that it should only be like a 5-minute process. And there are ways in everybody's wellness program to encourage employees to take the vaccine without requiring them to do that. Okay, I'm going to be really brief on the third and fourth questions. Which are the third one is, can we require employees to return to the workplace? And this takes us back to the reasonable accommodation requirement. Working from home may be a reasonable accommodation for employees who can do their jobs from home. So if an employee has like a medical reason for continuing to work from home, you engage in the same interaction. You request the documentation. You talk to your company doctor. You engage in the interactive process just like you do for everything else. One consideration is somebody wanting to work from home indefinitely or just for a few weeks while they get past a certain issue. Another consideration is, can the employee get the job done from home, basically? And there is a situation that affects, law firms and other professional firms, accounting, engineering, banking, financial consultants, more, because those kind of professions are kind of apprenticeship situations where younger professionals are trained by working directly, side by side with older professionals. And, a lot of these kind of firms have encountered some of their younger employees not wanting to come back to the office. And in this particular context, there is more of a business need for employees to return to the office. So some of these decisions are, going to kind of depend on your culture as an employer and also kind of the particular industry that you're in. I've got some slides on a case involving Ford Motor Company where they had a manager who had some medical reasons for wanting to work from home. And in this particular case, Ford did a really good job of documenting the interactive process and showing how they were willing to work with the employee, but the employee really wanted to kind of work from home indefinitely and kind of permanently. And Ford did a good job of explaining why that wouldn't work, why it was so important for the employee to be at the office. And long story short, at the end of the day, Ford won that case, even though the EEOC went to the trouble of filing a lawsuit on behalf of the employee and suing the company. And these are some, if an employee is working from home, it is a good idea for them to have like a telecommuting agreement or a work from home agreement. This slide gives you some considerations to include in that kind of an agreement. And then last question is, can we require some employees to stay home? Or another way to put it is, which of the employees who may want to work from home should we give extra serious consideration of their request? And, you can't exclude a qualified individual with a disability from the office if they want to come back unless they pose a direct threat. So that's the general principle. But the CDC issued some guidance a few months ago, I want to say like around August. They issued a booklet called the CDC Activities and Initiatives Supporting CDC. I'm sorry. The title of the document is Activities and Initiatives Supporting the COVID-19 Response. And if you look at pages 46 to 48 of that document, that section is called Interim Guidance for Employers with Workers at High Risk. And in there they said, you should give serious consideration to anybody who's at high risk, which is anybody who's age 55 or older or anybody who may have an underlying medical condition. If they ask to work from home, you should give serious consideration of their request because they have legitimate medical reasons for doing that. So you want to be aware of that because a lot of employers, especially here in the Southeast where we are, they want all their people to come back. But occasionally they do ask, can we keep somebody from coming back? And then, of course, a lot of employees would prefer to keep working from home. And this is a way to kind of separate maybe the cases where you will grant the request from the cases where you will not grant the request. And with apologies to William for running 5 minutes over my time, I'm going to turn it over to you now, William. Take it away.
Thank you, David. Great and timely information. Really appreciate David pulling that together for us. And again, as he stated at the beginning of our presentation, the slides will be distributed to everybody after this. I hope the audio portion of this is coming through loud and clear, and I'll continue. So, "2020 has been memorable already for COVID-19 reasons. But even if COVID-19 was not an issue in 2020, there's been a very important U.S. Supreme Court decision that fundamentally has expanded Title VII of the Civil Rights Act. And that's something we want to tackle today and talk about some best practices. So you'll see in our slides, we will talk about the Supreme Court decision holding that, quote, sex, end quote, discrimination covers LGBTQ applicants and employees. Then we'll go from there to religious discrimination under Title VII. We'll talk about some best practices, and we'll also talk about some of the, actually a collision between two protected categories of Title VII that is arising. So the cornerstone of the remainder of our discussion is Title VII of the Civil Rights Act of 1964. This law has been on the books for almost as long as I've been alive. So there's nothing new here, but rather what we've seen is in this very straightforward statute, there's been a lot of interpretation and application over the years. The case that we're going to be focusing on will be the term because of the individual's sex. But you'll see, and as you all know from prior webinars and training, Title VII contains protected categories based upon certain distinguishing features of somebody by belief or by their makeup. And here, the focus of the court was whether or not an individual's sex includes someone's sexual orientation. And the answer is yes. Now, before we start going down that path, just in terms of some background. So back in 1964, the Civil Rights Act was a controversial legislative initiative. And I'm told that in terms of the various protected categories that were added to this law, the term sex was added toward the very end. And there are a lot of theories about why it was included. One of them argues or states that it was included in an attempt to derail the law from becoming law. But indeed, it made it into the law, and I think it's a good thing that we have it, and you'll see that it's evolved. The term has evolved to include sexual harassment as well as now sexual orientation. So let's talk about the decision, and it got up to the U.S. Supreme Court. It was argued last year. The ruling came out middle of the summer in June of this year. While we were dealing with COVID, it came out, and we wanted to make sure that we highlight it now because it has some lasting impact for employers. So the case really was comprised of three different separate lawsuits. One was the Bostock lawsuit, and you see here a photo of Mr. Bostock. And he worked in Clayton County, Georgia, and he helped them as a child welfare advocate. He also participated in a gay recreational softball league. Others in the community noticed that he was doing that, and they within a little while of that, he was fired for conduct unbecoming a county employee. He filed a lawsuit, and his lawsuit was dismissed. The basis of the dismissal essentially was that Title VII does not cover sexual orientation, which has been the longstanding interpretation, but a controversial interpretation until this year, in which the court then decided to clarify some division between the various circuits on this issue. The second of the three cases was Altitude Express versus ZARDA. There's a picture of Mr. ZARDA. He was a skydiving instructor, and as part of that skydiving experience, it involved tandem skydiving out of a plane, and so that put him in close proximity with his customer. And during the course of that discussion, trying to alleviate a female customer's concern, he made a joke about "don't worry." In effect, "Don't worry, I'm gay," is what he allegedly told her. She reported it to the employer as a complaint, and then days later he was fired. He filed a lawsuit, and the Second Circuit, a different circuit court, concluded that Title VII does prohibit sexual orientation discrimination. So there was further illuminating the split between the genders. And then the third case was the case involving Harris Funeral Homes, and this one involved this opt-in who Miss Amy Stevens. She was born male. She worked as a funeral director for about 6 years, and during that period of time, she began her transition to female. Eventually, she told her employer through a very eloquent letter, and 2 weeks later, she was terminated. She filed a lawsuit based upon her transgender status, and the Sixth Circuit ruled that Title VII covered transgender employees, essentially. By the way, both Ms. Stevens and Mr. Zarda have since passed away, so the cases, this court ruling came out after they had passed away. This is an excerpt from the U.S. Supreme Court's decision, and it's the very first paragraph of that decision. And the justice writing that was very specific and eloquent. He said, "Today we must decide whether an employer can fire someone simply for being homosexual or transgender. The answer is clear." And he goes on to say, no, sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. And so over the course of several pages, the U.S. Supreme Court decides that Title VII indeed covers sex, and sex includes someone's status, sexual orientation status, specifically homosexuality or transgender, and is now the law of the land. And it's the opinion had a lot of or several dissents. So it was its decision. The court's decision was not unanimous, reflecting this somewhat controversial issue. But it is clear that the U.S. Supreme Court has ruled that Title VII covers this category. And now what do we do in terms of employers? And so that's what I want to talk about in terms of some best practices, and then we'll look at another issue. So nationwide now, for employers covered by Title VII, the law of the land is Title VII prohibits discrimination against LGBTQ applicants or employees. Now, Title VII's requirement of employer or definition of employer is triggered by somebody, an employer that has 15 or more employees. And that's going to be the majority of the employers in the United States. But what about the smaller employers with less than 15 employees? Well, those are going to be covered by state law as well. And those state laws have differed and continue differing. Some states specifically address this issue and explicitly prohibit sexual orientation and discrimination. And you see that 23 states do, 2 territories plus District of Columbia. South Carolina and North Carolina have statutes that essentially mirror Title VII and do not explicitly focus on sexual orientation. But what happens in South Carolina and North Carolina and other states is that that state law version it often looks to the federal interpretation of Title VII as persuasive authority. So it is not a big leap to conclude here that in the Carolinas, the state law that covers employers with less than 15 employees will reach a conclusion similar to the Bostock decision. So as employers, what are some best practices of what to do, what not to do going forward? Well, what we'll be talking about here will be no surprise, but it's very important. So you want to review your EEO and non-discrimination anti-harassment policies. And then you want to make sure that policy fits your situation, your employer's situation. And then you need to decide what needs to be updated. Well, at a minimum, I think you want to address, at least through a parenthetical and maybe through a paragraph, that the prohibition against sex discrimination and sexual harassment includes the prohibition against LGBTQ discrimination or harassment, meaning sex discrimination is inclusive of sexual orientation. And you could say that in a few words or many words, but I think it's important that you say it and then you follow through on it, because one of the thing that's worse than having a policy that is wrong is having a policy that is right that you just ignore. Okay, it's at least worse, perhaps equally bad. So we want to make sure that if you have a policy that's up to date and that you are following through on. Part of having a policy is also communicating that policy. And so many of you all conduct anti-harassment and anti-discrimination training for your managers and employees in some contexts on a regular basis. This change this summer would be an opportunity and a really good reason to have some refresher anti-discrimination, anti-harassment to cover this issue, among others. So consider that as you're planning your training schedule for 2021. This leads into another issue, one that frankly I never thought I'd be talking about on a webinar, but it does make sense in this context. And that is about bathrooms in the workplace. It's a fundamental part of being human. And under OSHA, employers have the responsibility of under the sanitation standard of providing toilet facilities. So the question is, how does that apply to a sexual orientation situation? And we've already had guidance about this. And I'm going to illustrate that guidance in just a moment. It is right now guidance, but we would expect the EEOC to start aggressively enforcing that guidance going forward. So essentially, the bottom line here with regard to bathroom facilities is that each employee determines which restroom is appropriate for him or her or that person to use. And an employer should not require medical or legal documentation to confirm or refute that type of determination. And that a single occupancy bathroom is a good idea, but should not be a mandatory requirement. So that's essentially the guidance that we've received from both OSHA as well as the EEOC. So displayed on the screen right now is information from OSHA that has been previously distributed via their internet. Take a look at it. You'll see it in the slides that you received. There's good information on the OSHA website. And similarly, the EEOC had issued some guidance about this earlier. And the EEOC for several years has been actively enforcing this on an administrative basis and indeed holding, at least with some government employers, that failure to do those guidelines that I just summarized constituted Title VII discrimination. So we would anticipate that we'll see more of that coming up in the future. And that can be a controversial thing in the workplace, but I think communication and understanding is important here as you're the employer trying to balance the competing interests that are going on. That leads me to dress codes. So David and I have been in the labor and employment business for a long time, and I dare say we've reviewed hundreds, if not thousands, of employee handbooks and personnel policy manuals. It used to be a very standard provision there, and still is for many employers, to have a dress code standard. On your to-do list for 2021, take a look at your handbook and look at specifically whether or not your dress code policy or procedure needs to be updated. Chances are it does, because now we should be shifting away from sex-specific dress codes and going more to a generic, professionally appropriate attire focus. So instead of talking about how short or long a dress needs to be, or what tie someone could or should wear, we'll be talking more about professional attire, and regardless of one's gender. And that should be addressed in 2021. In our remaining time, we'll briefly talk about religious discrimination. We've already acknowledged that Title VII prohibits discrimination based upon certain protected categories, one of which is religion. That's been on the books ever since it was passed into law, along with sex discrimination and the other categories. So Title VII prohibits discrimination based on religion. Two things have come up of late. One is the ministerial exception. Now, this is an exception. There is some religious discrimination that can occur, but that will be involving a religious entity that can make those discriminatory decisions, meaning doing things even though it's covered by the law. And whether or not that exception applies depends on the employees and what they're doing. So a religious teacher at a religious school, the religion sponsoring that school could expect that teacher would be complying with whatever the religious precepts are, and then take action if that did not occur. That's the type of exception we've talked about. And in a moment, we'll see how that may or may not play out going forward. Also, this is not part of Title VII, but the Religious Freedom Restoration Act. It's not an employment type of law, but it is. We'll continue hearing much more about it in the coming year. It's in effect a super statute that applies to religious freedom and an action by the government that may infringe on that. It was one of the defenses pled in one of the three cases we just looked at earlier, but it was not pled for the Supreme Court's review. So the Supreme Court said we're going to decide that issue at another day. So it's going to come back. And here, this next slide illustrates how religious discrimination protection and sex discrimination protection, which includes sexual orientation, can collide in the workplace. So this is a photo, I'm told, of a cashier, not the cashier, but a cashier at Kroger, a grocery store chain. And although it is very difficult to see on this slide, you'll see that on the blue apron, purple apron, is a heart-shaped patch on this cashier. And that heart-shaped patch, I'm told, is multicolored, rainbow colored, and two employees working at Kroger in Arkansas objected to having to wear that heart patch and said it was contrary to their religious belief, and they refused to wear it, and they were fired at least that's the facts as I understand them to be alleged. The EEOC agency brought a lawsuit this summer against Kroger, generally based on those facts, saying that those employees' rights to be free of religious discrimination had been violated. The case has not been decided. It is controversial. It's controversial within the EEOC itself as well as in the general public. And it will play out in the coming year, but it illustrates the collision of these two laws, and I would expect we'll see more of that. Now, the underlying information or some anecdotal information from Kroger that's been put out as part of a press response indicates that the heart-shaped patch that I'm putting the cursor on right now was reflective of Kroger colors and Kroger principles, not related to LGBTQ issues. Rather, there was a separate patch that was a voluntary patch that could have been worn by Kroger employees related to that. So there's always two sides of every story, but the point of this slide is to illustrate that this remains a controversial issue in the workplace. There are strong feelings on both sides of this. And just like we saw a lot of civil unrest in the workplace this year about other very important issues, this can be a polarizing issue in the workplace as well. That can trigger Title VII laws as well as National Labor Relations Act, Section 7 activities. So as you look ahead on this one, just be mindful of this issue, and under the new administration, indeed, this may change. Now, last two slides. Anytime we talk with HR managers about a particular employment law situation, I bet you'll hear David or I or one of our other great attorneys here at Nixon Pruitt ask you, well, what does the documentation say? What's the documentation in that personnel file say about this person? And oftentimes that personnel file is pretty thin and there's no documentation. So one point here is it's better to have documentation, but it's even best to have documentation that is what I'll say helpful or effective, meaning it needs to be, and that's what the next two slides talk about, it needs to be accurate. Okay? Make sure all the dates and facts are correct. And in terms of the date, one date you'll see me echo here is don't backdate your documentation. If you're filling it out on December 9, don't cross it out later and say it's December 10 or vice versa. In other words, stick to the dates. If you're supplementing it, just clearly state or document when you're doing it. Be fair, don't exaggerate. Be kind. You don't have to run somebody in the ground, but basically stick to the facts. And there used to be an old TV police show called Dragnet. You guys may remember it. And there was a famous saying in there, just the facts. And you really need to, it's best to stick to the facts and to avoid jumping to conclusions. And as part of the guidelines for documentation, oftentimes you'll want the employee to sign it, or at least ask them to sign it, particularly if it's the result of an investigation, or if it's a performance evaluation, or if it's a warning. So it's, in effect, acknowledging that they saw it. They don't have to acknowledge that they agree with it. And if they refuse to sign, you can note that, and then you put it in their file so that if you, the employer, have an issue that's come up at work and that you have to debate or discuss what's happened in the past, be it about a discrimination issue, about a training issue about anti-discrimination, or about other issues arising out of the workplace, you'll have documentation that will support that the employer has a policy, the employer took this seriously, the employer enforced the policy, and took appropriate action. So with that, we've covered a lot of important areas during this short hour. As we look ahead to 2021, chances are it's going to be another challenging year. Lots of lessons we've learned in 2020, and we hope that you, as employers, are learning those lessons going that we learned in 2020 and putting them into play for 2021. It's a privilege to be on this webinar with you all. If David or I or any of our great attorneys at Nixon Pruitt can be of assistance to you all, please reach out to us. Again, many thanks to Mickey and the rest of our team here. They will take this presentation and email it to the participants. And if you all have any questions, you are welcome to contact us. We thank you for your time today, and we wish you happy holidays going forward. Have a good afternoon.